My favorite thing to do as an attorney is to cross-examine people, to have the other party or the other party's witnesses on the stand and try to demolish them and point out their lies, inconsistencies, problems with their testimony or their story. And in this video, I'm going to be teaching you how to survive and even win in cross-examination, because when you are cross-examined, when you are asked questions, it is testing your story. It's trying to poke holes in it. And if you and your story are impervious to holes, that is how you convince the judge, you convince the jury, you convince whomever you need to convince. And this applies to really every type of case. I am a criminal defense attorney. I do domestic violence cases and restraining order cases, but I've also tried cases all the way up to first-degree murder. I have also tried civil cases. And so if you have a case where you may eventually be put on the stand as a witness, then this video is for you, because I'm going to be going through 9 of my best tips on how to survive cross-examination. My name is Veronica. As I said, I am a domestic violence defense attorney here in the state of California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you from start to finish everything that you need to know to represent yourself at your restraining order hearing and win. So if you find yourself in that situation, you can get your free first class via the link down below in the description box. Okay, so let's get into this. My 9 best tips on how to survive and even win your case in cross-examination. And tip number 9, I know that there are a lot, but if you're in this situation, you probably need all the help you can get. People are nervous usually when a lawyer is going to cross-examine them. Tip number 9, though, is the best one, and that one gives you the exact language that a lawyer will probably use. That should be a red flag in your mind as to what's coming next, and I will tell you how to stop them. So number 1, listen carefully to each question. I know that that may seem like a given, but really make sure that you understand the question completely before you answer. And if something is unclear, it's okay to ask for clarification to make sure that your response is accurate. Attorneys often ask bad or confusing questions. So if you don't understand the question, it doesn't mean that there's anything wrong with you or that you don't know what's going on. It's probably because they made the question up on the spot and it's a bad question. Some examples of what you might say to express that you don't really know what they're talking about is, would you mind repeating the question? I'm not sure if I understood it. Or are you asking, X, Y, Z? And they might actually fumble a bit and say, let me rephrase, or say, I'll strike that question and move on. Number 2, keep your answers focused. Make sure that you only reply to what is asked without volunteering additional information. So if you are asked, did you send an email to the petitioner on August 1st? Just respond yes or no. Don't start talking about what is in the email. I actually was watching a restraining order hearing recently while I was waiting for my case to be called, where the judge noted when deciding, and both sides had witnesses who basically just testified to the opposite of one another, right? So there are 2 competing versions of events, and the judge has to decide which one to believe. And for restraining orders, for domestic violence restraining orders, it's slightly more than 50% that the judge has to believe. And the judge found in favor of the respondent, saying that when the respondent and the respondent's witnesses were asked questions, they responded with simple yes or no answers without adding anything additional. Witnesses often think that they are being persuasive when they start to tell their whole story again or go on, or they can tell what the lawyer is getting at and they try to argue with the lawyer, but it is not persuasive to the judge. So you're asked something that maybe you wish that the answer wasn't yes, right? Like, did you send an email to the petitioner on such and such day? You wish you didn't, but okay, you did. Maybe it's not a positive thing for your side that you did. It's probably not if you're being asked about it on cross. When you just say yes, you're kind of saying, so what, right? You are not giving that fact any more weight than it deserves. And so for domestic violence cases and restraining order cases, a big one that we often will ask the petitioner or the alleged victim if there was some incident of abuse. And then after that, the petitioner and the respondent got back together, or the alleged victim and the defendant got back together. We will point that out and say, isn't it true that you saw him the next night? You went on a date. You sent him a heart emoji. And And if you just say yes to that, instead of saying, well, yes, but that's because I was afraid of him, or yes, but I didn't realize at the time that what he was doing was abuse, it's much less persuasive than simply saying yes, because the so what is sort of implicit there. Number 3, remain calm and respectful. Again, this may seem easy. This may seem obvious, but it can be very difficult to do in court, especially if you're talking about really personal issues. And your demeanor when testifying is key to whether a judge or a jury believes you. Now, if you are a defendant, or you are the person who is accused of domestic violence, or if the defense is self-defense, then the opposing party's attorney is going to try to rally you up. Just be prepared for that. It's probably literally in the Word document of their outline for questions to try to rally you up. It's in every course in law school about how to advocate for your client at trial. If you appear angry, then their version of events will become more plausible. The judge and the jury will be able to see, to picture in their mind's eye, you doing exactly what you are being accused of. So be prepared for that, and don't let the other attorney rile you up. Even if you really don't like that person, they are trying to make you seem like something you're not. They're saying things that are just not true, which they may say, even if they don't have any evidence of them, just to see if they can get a rise out of you. Just know that that is what they are doing, and it is in a textbook, and they are probably using a template from a textbook or something that they learned from another attorney, and they're just trying to do their job well, and it sucks. But don't let that ruin your case. Number 4, avoid speculation. If you don't know something, then you can say, I don't know. That's a perfectly valid answer. If you don't remember something, you can say, I don't recall. Now, don't abuse that, because if you are saying I don't recall about something that anyone would or should recall, then that will hurt your credibility. But if you genuinely don't know, you don't recall, you never knew in the first place, then that's a totally fine answer. And in fact, if you say that, then the judge will probably make the other attorney move on from that. Number 5, correct mistakes promptly. Sometimes we misspeak, right? If you realize that you have made an error in your testimony, maybe in your testimony when you were explaining yourself in the first place, maybe during cross-examination, it's okay to correct that. And actually, it can potentially add to your credibility. So as an example, I mentioned earlier that I left the meeting at 3 p.m., but thinking it over, I realized that it was closer to 4 p.m. So I wanted to make sure I clarified that for the record. That's a totally fine thing to say. That makes you sound very reasonable and very credible. Number 6, sometimes you're just going to have to say yes or no, and just recognize that some questions are direct and require straightforward answers. So don't try to add extra stuff. But this is something that witnesses often really struggle. So as an example, did you call the petitioner on the night of July 15th? And there are phone records that show that you plainly did. Maybe you haven't seen them, but they're probably out there, and the attorney probably has them if they're asking you about this. If you called the petitioner on the night of July 15th, just say yes. Don't explain why you called or what the phone call was about, which is what a lot of witnesses would do unless you are asked. Number 7, this is a really big one that I don't think a lot of attorneys teach their clients, but I think is so important. You need to be very cautious with absolutes. A big red flag is going to be if you hear the other attorney say always or never. Remember standardized tests? I remember my parents made me go to a class about how to be good at standardized tests. It's all just about tips and trying to outsmart the test, right? If it says always or never, if there's even one instance where that's not true, then if you say yes to always or yes to never, then you're wrong, right? Then you lose. And so if a lawyer is asking you that, you never yelled at the petitioner. You always would lock the door. You may think, well, yeah, I mean, I always would, but not thinking, oh, but okay, there was the one time that I didn't. So when you hear always or never, I hope you remember this video and think, okay, I shouldn't agree with that. I shouldn't just say yes to that. I should say, to the best of my recollection, I should say, as far as I remember, that is correct. But don't just flat out agree with an always or never statement. Number 8, documents. All right, so here's a little secret. It can be very difficult to bring a document into evidence on cross-examination. As attorneys, when we want to bring a document into evidence, we have to establish certain things. We'll say, I'm showing you what's been marked as Exhibit A. Do you recognize it? What is it? Is this a true and correct copy of whatever the document is, right? And if we have a friendly witness, if it's our client or our witness, it's a document that they know about, an email, whatever it may be, right? And they say, yes, I recognize this. What is it? Oh, it's an email. Is it a true and correct copy? Yes, it's very, very easy. But sometimes we can't really establish, that's called foundation. We can't really establish foundation with our own client necessarily, because maybe it's something like your Instagram post or something that we don't really have a witness there that can help us bring that piece of evidence in. Sometimes the opposing party doesn't really know what's going on and they're sort of agreeable and they don't really understand what we're doing or what we have to do there, and they will go along with us. And we show them a copy of their text messages that our client brought in. And if in a criminal defense trial, I might not want to put my client on the stand. And so if the text messages are between my client and the alleged victim, I don't really have a way to get those text messages into evidence, which means to show them to anyone, to the judge or the jury, unless you, as the alleged victim, will go along with me and agree with me about the text messages. Or maybe it's text messages between you and some other person that for some reason isn't available as a witness, and so their only shot to get it in is through you. So if the other side shows you a document that your side did not produce, you didn't give it over to your attorney, for example, and then they turned it over to the other side, and they ask if you recognize it, don't commit. Because look, if it is text messages or an email, how do you know that the other side didn't alter them? What you can say is, if it's text messages, for example, well, those look like they're text messages probably between me and someone else, but I don't know. I haven't seen this. I would have to compare it to my own messages in order to make sure it was accurate. If you say that, they're not going to be able to bring that into evidence. They will not be able to establish that foundation. Another thing that the opposing attorney might do regarding documents, if it is text messages or something like that, they might ask you, isn't it true that on July 10th of 2023, you texted my client and then whatever the text message is, right? So they might try to quote something. And you might say, well, I don't recall. I don't recall sending that, right? So you followed the previous tips. And they might say, would it refresh your recollection if you were to see a copy of the text messages? In that case, what you want to say is, well, yes, if I saw my copy of the text messages, it would. What they're trying to do there is they are trying to show you a copy of the text messages that they have, that their own client gave them. They're trying to give those to you while you're on the stand and have you read that and then confirm, admit whatever you sent. But the thing is, again, that copy that they are showing you would not necessarily refresh your recollection because it's not your copy, right? If you were to go to your own text messages that you have and you were to review them, your copies that you know are correct, that you know are unaltered, then that would refresh your recollection. But seeing some document that the other attorney gives you that says you said something on July 10th doesn't mean that you did it, so that would not refresh your recollection. So what you can say in that instance is, seeing my own copies of the text messages would refresh my recollection. But seeing this document that I've never seen before does not. And then again, they cannot get that text message in. They're going to have to just move on. Number 9, and this is the most important tip here, and I think also the easiest one to master, to get right, and I hope that this one sticks in your mind. The other attorney is going to try to directly show that you are lying by showing some other evidence, by having a witness, usually a third-party witness, or because they have a document that shows something different than something that you have already testified to. But in order to be able to do this, in order to be allowed to impeach you procedurally, to be able to show that piece of evidence, in order to be able to have that witness come in, and maybe it's a surprise witness, the only way to do that is first to get you to commit. Now, how they do this, so this is the exact language that they will probably use, or very close to it if they know what they're doing. What they will say is, you testified to whatever fact it is. Okay, that will be the first question. So they'll ask you about something that you just said, or maybe you said on a previous occasion when you were under oath, at a deposition, at a previous hearing. And then they will say, are you sure that whatever the fact is? When you hear that, are you sure, or are you certain? Are you positive? Something along those lines, what they are doing is they're setting up to impeach you. Okay. And they probably have evidence that whatever you testified to is not exactly accurate. And what they want, and they're gearing up to do, and they're really excited to do, is trot out that witness, or more likely show a document to you and to the jury, the judge, to paint you as a liar. Because maybe if you've been telling the truth the whole time, maybe you just got something wrong. Maybe you misremembered, right? So when they say, are you absolutely sure, or something along those lines, again, they are looking for an absolute. If they do not get it from you, they cannot impeach you. They are not allowed to. Trot out, to the best of my recollection, that is correct. Or as far as I recall, because then you are not giving an absolute, and generally they will not be able to impeach you if they attempt to. In one jury trial that I won for my client, and I think we should have won, it was a domestic violence felony case. You know, it's always difficult when it is sort of a he said, she said situation. But 12 jurors are looking at my client. There's a victim on the stand saying I was abused, and the testimony of one person is enough to potentially convict you. And so my job as a defense attorney, in large part, is to poke holes in her story. And one thing that I asked her about, that she, at the preliminary hearing, which is like halfway through a felony case, basically, she had testified that she had broken up with my client. Now, after the preliminary hearing, my client's like, that's not true. That didn't happen. He gives me a text message where he's breaking up with her. And really, to be fair, they had broken up on multiple occasions. But he did have a text message that was on the date in question. You know, if somebody breaks up with you, you can't then break up with them. They've already done it, right? Their relationship's already over. And I asked her, you testified that you broke up with him. She says, yes, I broke up with him, right? She's mad. She did not know any of these tips or follow them. Are you absolutely sure that you broke up with him? And she was like, heck yes, I am absolutely sure that I broke up with him, and even talked a little bit, which again didn't make her look good, about why she broke up with him. And by saying that, she said exactly what I was hoping for, because I had the text message right there. I was eager to show it, and I saw exactly how the jury looked at her at that point, and I'm confident that that is the moment that we won the case. And just because my client broke up with her versus her breaking up with him, that doesn't necessarily go to the elements of domestic violence or what has to be proven by the prosecution in order for them to win and convict my client. But what happened is that her credibility was just destroyed, because she had said absolutely no. And then immediately after, everybody sees a text that I put on the projector where he breaks up with her on that same day. And what she could have said to shut me down was, to the best of my recollection, I broke up with him, but it was a really stressful time. I think we both broke up with each other a few times. At that point, I wouldn't have been able to use that text message. And then I don't know what would have happened for my trial. I hope that you found this video helpful. If you do have a case in the state of California, feel free to give me a call. You can also book a consultation down below. If you do have a restraining order case and you're planning to represent yourself, or even thinking about it, make sure you get your free first class in my course. You can get that via the link down below in the description box. And if you did find the video helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.